Hello and welcome back to my channel. I'm not going to lie to you, today is a very tough day for anyone who is following the It Ends With Us saga and is on Team Wayfarer and BALDONI. I'm just so sad sitting here in front of you, and it's with a super heavy heart. And I've been following everyone all day reporting on this, and I really wanted to read all the documents and take it in before I just rushed to the camera and, give you the breaking news. It sucks. It's a bummer by now, or maybe you don't know, and I'm the first to tell you, but the judge has come back and he has granted the motions to dismiss for Ryan Reynolds and Leslie Sloan and the New York Times. The Wayfarer people, those allegations were huge, right? They took huge swings, and unfortunately, they're not good enough in the court of law. But the silver lining and the good news is now we know what happened. We know and see Ryan Reynolds and Leslie Sloan for exactly who they are. We know that the New York Times definitely, through metadata, colluded with the Lively Parties since October. The metadata shows at least 100% since the beginning of December. And it could have just been that the Wayfarer Parties didn't just want to defend themselves, and that's why they put in as plaintiffs, and they fought hard. And you know what? Now we have the truth, and that's a silver lining. And I am never going to stop fighting, and I'm never going to stop showing you evidence that this is a pattern for Ryan Reynolds, that this is what he does. But it is just a very sad day because yet again, the big and the powerful get away with very morally corrupt things. But like I speak about here, there is a difference between morality and legality. And unfortunately, right now in the legal systems, this is just such a big win for the Lively Parties and a huge setback for Wayfarer and BALDONI. But just know that Brian Freeman and Kevin and all the other lawyers that they probably have an action plan, and they either kind of knew this was coming and what to do next, or, there's going to be more. So without further ado, I'm not really sure how much emotional lip gloss will help you, but grab your emotional lip gloss. We're going to go through the court filings. To save time, I did go through it. It's 130 pages. So we're only going to read what I found to be the most relevant, just so you can see it yourself and see what the judge said instead of reading all the headlines. But yeah, and I'm appearing like this. I'm showing up today as I am, okay? No prep, no hair, no makeup. This is it. This is what you get. You're in frame with Mandy Magnan. Before we go into the big filing that was done today, this was also filed, and this just shows the Marvel Entertainment now gets to be, out of this too, since Ryan Reynolds is out of it. But the motion by Marvel Entertainment LLC to squash a subpoena issued to Marvel from the Wayfarer Parties for protective order prohibiting the disclosure of Marvel's confidential documents is granted. Yay, so cool. Then it goes on to say that the motion by Leslie Sloan and Vision PR to compel the Wayfarer Parties to respond and produce documents is also denied as mute because now Leslie Sloan has been dismissed. The motion by Sloan Parties to compel James Vituska to produce documents has also been withdrawn because, it's not, I guess, important anymore to see it. So yeah, super cool. Anyway, let's move on. I know that we're all angry, and I know that we're all hurt, and I know that this is all very confusing and doesn't make any sense because we saw it. We see what's going on. We saw the timeline, okay, but I guess in federal court, it doesn't matter. One of the things, though, I do want to make very clear is that the judge never ruled on the California anti-SLAPP legislation of 47.1. Even though 19 to 22 people or organizations submitted those amici briefs, he never made his ruling from those amici briefs. He was already putting this together. I mean, it's a huge document. It probably took a long time. So he was already ruling before all those amicus briefs, and he never actually had to rule on the anti-SLAPP 47.1. Yay. I'm so sorry. I'm trying my hardest, but I'm angry like everyone, and I'm frustrated, and I feel things, and I'm really feeling for the Wayfarer parties. But now we know at least exactly what happened, This is the opinion and order. So consolidated defendants Blake Lively, Ryan Reynolds, Leslie Sloan, Vision PR, all together the Sloan parties, or Sloan, the New York Times Company, the New York Times, or Times. The amended complaint makes no allegations against Vision PR Inc. other than it is together with Lively, Reynolds, and the Sloan parties. Each moved to dismiss the amended complaint of Wayfarer Studios LLC, Justin Baldoni, Jamie Heath, It Ends With Us Movie LLC, Melissa Nathan, Jennifer Abel, and Steve Soritz, collectively the Wayfarer parties, pursuant to Federal Rule of Civil Procedure 12B. Reynolds, Sloan, and Vision PR additionally move for an award of attorney fees and costs pursuant to New York's anti-SLAPP law, New York civil rights law. Lively moves for an award of attorney fees, treble damages, and punitive damages pursuant to California Civil Code. Finally, Lively, Sloan, and Reynolds move to strike Exhibit A to the amended complaint pursuant to the Federal Rule of Civil Procedure. Exhibit A is the timeline of relevant events that the Wayfarer people attached with their amended complaint. For the following reasons, the motions to dismiss are granted. The motion to strike is denied, but the court will disregard Exhibit A to the amended complaint for purposes of this motion. The motion for fees are denied without prejudice to renewal. Then they go into the background, and these are things that we all know, but it is pretty crystal clear just by reading the background, so I thought it would be good just to go over. It's kind of quick, but we'll just go over it and then we'll get into the juiciness of it all. The Wayfarer Parties amended complaint contains allegations regarding a dispute between two well-known actors over the making of a Hollywood motion picture. Virtually every fact is hotly contested. For purposes of this motion, the court accepts as true the well-pleaded allegations of the Wayfarer Parties amended complaints. This dismissal, what he's saying, is based off taking everything that the Wayfarer put into their amended complaint. So he is looking at it as best light for the Wayfarer people to make this decision. It just, unfortunately, what he says is this kind of just wasn't good enough. Accordingly, the narrative set out below does not reflect the court's own findings, but simply repeats the accounts of events stated by the Wayfarer parties in their amended complaint. At this stage of proceedings, the court has not considered whether the allegations in the amended complaint are true. In addition to the allegations in the amended complaint, the court has considered several documents which are deemed to be part of the amended complaint as a matter of law. A complaint is deemed to include any written instrument attached to it as an exhibit, materials incorporated in it by reference, and documents that, although not incorporated by reference, are integral to the complaint. If a complaint makes clear, definite, and substantial reference to a document, for example, by quoting from it extensively, the entire document is deemed to be part of that complaint. The purpose of this rule is to prevent a complaint from surviving simply because a clever plaintiff included certain parts of a key document and left out others. The purpose of the rule is to prevent complaints from being invulnerable at the motion to dismiss stage purely by clever drafting. Under this standard, the amended complaint is deemed to include the New York Times article that is the subject of the Wayfarer Parties' defamation claims, the accompanying video, Lively's California Civil Rights Department CRD complaint, a list of 17 protections demanded by Lively to return to production in November of 2023, and emails between the New York Times and the Wayfarer Parties. Each of these documents is extensively quoted and discussed in the amended complaint. The complaint also relies heavily on the terms and effects of each document, either because it alleges the terms are defamatory, or because it alleges they constitute a contract. In determining whether the Wayfarer parties have stated a claim for relief, the court does not consider Exhibit A to the Wayfarer parties' amended complaint. Under the federal rules of civil procedure, a defendant is entitled to know the allegations against it and to have those allegations framed in separate paragraphs with sufficient clarity to allow the defendant to frame a responsive pleading. Refusing to consider an affidavit buried in 170 pages of exhibits attached to the complaint because it would do considerable damage to Rule 8A's notice requirement. A party must state its claims or defensive in numbered paragraphs, each limited as far as practicable to a single set of circumstances. The body of the Wayfarer party's amended complaint is 224 pages long. Exhibit A is a timeline providing a summarized account of the sequence of key events, which is an additional 168 pages long. It is significantly but not entirely repetitive of the amended complaint, and it does not set out its claims in numbered paragraphs as required by Federal Rules of Civil Procedure 10. Well, I already knew that. If you watched any lawyers that have been following that case, when they originally put that Exhibit A, like the timeline of relevant events, they already knew that that wasn't like, I think that was mostly like for us to read as well as for everyone to like get the detailed things. A lot of people knew that that was going to probably get stricken or, like he's saying, he never used it in order to do this filing because it was kind of like the same thing. The document is not a written instrument that evidences legal rights or duties or otherwise forms the basis of the Wayfarer's claims, but is simply an additional narrative summary. If such a document could be deemed part of a complaint, then Rule 8A requirements of a short and plain statement of a claim for which relief could be granted would be eviscerated. If the Wayfarer parties wanted any factual statement in the timeline to be considered, they should have alleged them in the amended complaint. So he's saying whatever is in Exhibit A of the timeline of relevant. Oh my gosh, help me out, guys. Whatever is in that timeline, if it is not in the amended complaint, he's not considering it because he's only looking at the amended complaint because the timeline of relevant events doesn't even have the right formatting to be considered a proper document in the courts. So he's saying whatever is in that, timeline of events, if you wanted it in your amended complaint, it should have been in there because that's only what he's looking at. So I just want to look over some of the footnotes that I found pretty interesting here. It says, at this time, the court will not grant the motions to strike Exhibit A from the docket. Exhibit A is a largely redundant of the amended complaint, and given that it must be disregarded, it's immaterial to the court's decision on the motion to dismiss. But the fact that material is irrelevant or must be disregarded generally does not satisfy striking from the docket unless permitting the allegations to stand would result in prejudice to the movement. None of the defendants have identified any particular prejudice caused by Exhibit A, a document which is no more scandalous than the amended complaint. At the conference on February 3rd, 2025, counsel for Lively and Reynolds expressed some concern about the use of the attachment on a website created by defense counsel and stated that they would move promptly to strike the exhibit. But the earliest motion to strike was made by Sloan on February 20th. Reynolds and Lively did not move until March 18th and 20th. More importantly, none of the motions mentioned anything about improper or prejudicial use of Exhibit A. Motions to strike are generally disfavored and should be granted only when there is a strong reason for doing so. Absent prejudice or impropriety, there is no strong reason to strike the document as opposed to simply disregarding it. So, wow, thanks so much for not striking that document. But, then they go over a lot of the background and timeline of the movie, like who the people are, And what I think is really, really funny and quite relevant is how he states Blake and Ryan. Blake Lively is an individual residing in New York, New York. She played the lead role of Lily Bloom. Ryan Reynolds is an individual residing in New York. Ryan is married to Lively and is a well-known actor. So much more. Oh my gosh. They're really downplaying their power and just stating them as just like actors or just the husband. Ugh, gosh, I just can't. And they go into the timeline. So the timeline of the entire thing. And maybe I will do a separate video about the exact timeline so that people know what is going on. But for the purpose of this video and for time, if you know what they're stating and what the allegations are against them. The judge, I did read everything, and he does seem to understand exactly what the Wayfarer people have alleged. Like, he states it fact to fact to fact, and it really doesn't make Lively look good. Like, it makes her look like a monster that came on and stole the movie, and that there were disagreements between her and Baldoni, and everything that the Wayfarer alleged he put in, like, as a timeline, point by point by point. Just to show you, though, like, the judge knows the entire story, right? Like, he knows, like, he even wrote here in July 2024, this is where he's going over the factual breakdown of everything that's been alleged. In July 2024, Lively's social media post promoting the film took a lighthearted turn, focusing on fun, fashion, and floral motifs. She also promoted the launch of her new hair care line, Blake Brown, which was timed to coincide the film's release, and her alcohol brand, Betty Booze. He does talk about also the Deadpool and Wolverine. Nicepool is shot and killed by a character voiced by Lively. During the premiere of Deadpool and Wolverine, Reynolds approached an executive at WME, Baldoni's agency, and told him Baldoni was a sexual predator. At a later date, Reynolds also demanded that WME drop Baldoni. WME also represents Lively and Reynolds. Like, he does acknowledge, too, that, in the red carpet interview at the New York premiere of the film, It Ends With Us, Lively stated that Reynolds actually wrote the rooftop scene. The Wayfarer Parties and Sony were not previously aware that Reynolds, who had no formal role in the film, contributed to it at all. On August 8th, 2024, 2 days after the premiere, Nathan and Lively's publicist Sloan agreed that neither would speak to any reporters about the problems between Lively and Baldoni without informing the other. However, Sloan then immediately, and if I'm wrong, strike me down now, but I think it was something like 9 minutes later or something, she broke the truce. Blake's team broke the truce. Who's smearing who, okay? However, Sloan then immediately responded with a text, and then, about that. I mean, he knows everything that happened. He wrote it out all here, like, point by point by point of almost everything that's going on. So it's not like he was unaware of all of the claims and everything that happened in the relevance, in the amended complaints by the Wayfarer people. And just talking about the smear campaign, I mean, he even wrote here that, like, in the days after the premiere, Lively received a wave of online criticism for her marketing of the film, which was criticized as shallow and tone deaf. Yes, it was, and it still is. I mean, I don't even want to get into everything that she's still doing online right now, because it's actually disgusting me. All of her Instagrams, the way that other person, like a girl just came out and said how rude she was, and then 24 hours later, Blake showing up with other people. Shut up, okay? So done with you and your husband. Like, let me tell you, okay? But anyway, it does say here, like, her cross-promotion with her alcohol brand were criticized due to the ties between alcohol and domestic violence. A post stating, "Grab your friends, wear your florals," went viral and was perceived as insensitive given the film's focus on domestic violence. On August 9th, 2024, Jamie Heath emailed Sony noting that many people are pointing out that the DV is being glossed over and that Justin is essentially the only one promoting the subject matter, while others might not be giving it the proper respect it deserves. Does that sound like a smear campaign? They're literally telling you that what you're doing, your marketing, is not being well received, and to pivot. That doesn't sound like a smear campaign to me. That seems like Blake and Ryan did whatever they wanted to do to promote this film, which Ryan wasn't even a part of. And when Wayfarer found out that, hey, we're getting a lot of criticism and people aren't really liking it, maybe you're going to want to change what you're doing with marketing. I mean, that sounds like to me that they just hit the nail on the head. They weren't smearing you behind your back. They were letting you know straight up to your face what the frig is going on. And then he does go on about how there are text messages that prove that there is no smear campaign. But then also he says there are some text messages that maybe would show that there was a smear campaign. But if you look at just these text messages, like, there definitely wasn't, like, Baldoni expressed worry about the perception that we are planting these stories, which is not true, obviously. And Jennifer Abel stated that he should not worry because the people saying that they are bots and this is a PR play on your side is a minority voice compared to the thousands and thousands who are calling it what it is and reacting to Blake's own actions and interviews. Baldoni asked, "How can we say somehow that we are not doing any of this? It looks like we are trying to take her down." And Nathan responded, "No, it doesn't." As in, hello, Justin Baldoni the whole time didn't want to smear you. He didn't want any bad blood. But now we got bad blood. Do you know? Like, he was really trying this whole time to protect the film, protect the message, protect himself, as well as still protect Blake. I mean, it is so obvious to me the kind of people that Jamie Heath and Justin Baldoni are. And even through their own text messages shows that all they wanted to do was just power through, keep the message of the film, and move on out of the claws and the grips of the monster that she is, Blake Lively. Like, he knows about the screenshots and about how that they were grabbed and how they removed emojis like this one. He writes here, the Wayfarer Parties allege that Lively and her team used cherry-picked text messages, stripped of context, and even manipulated to peddle a narrative that the Wayfarer Parties had responded to Lively's complaints about purported sexual harassment by plotting to destroy her reputation through a shadow smear campaign to the New York Times. It states that Lively selectively and deceptively edited the text messages in her CRD complaint, and apparently in the materials she forwarded to the Times, to tell the false story that the Wayfarer Parties committed public relations sabotages as revenge for her sexual harassment complaints. For example, Lively's CRD complaint includes the message from Ableton Nathan stating, "You really did outdo yourself with this piece," while omitting the upside-down smiley face and preceding messages suggesting that this comment was sarcastic. From the factual background, like where it tells us step by step of all the allegations that are coming, then it goes into the history of the procedural history. So on December 31st, Lively filed a complaint against the Wayfarer Parties in this court, bringing claims for sexual harassment, retaliation, breach of contract, and intentional and negligent infliction of emotional distress. The Wayfarer Parties then filed their original complaint on January 16th, 2025. And then it goes into all of the filings pretty much since then, like all of the dates of the filings since then, which we all know because we're all caught up, okay, girl? However, this is where it gets interesting. However, the Wayfarer Party stated that if the court were to grant one or more of the motions to any extent, the Wayfarer Parties will move for leave to amend pursuant to Federal Civil Pursuant 15A. Let's go to the legal standing. And don't worry, it is 130 pages, but I'm not going to read all of it to you. I know we're all angry, so let's just try to get through this and have a little chat at the end, maybe if I have it in me, okay? To survive a motion to dismiss pursuant to Federal Rule of Civil Procedure, a complaint must include sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. A complaint must offer more than labels and conclusions, a formalic recitation of the elements of a cause of action, or naked assertions devoid of further factual enhancement in order to survive dismissal. The ultimate question is whether a claim has facial plausibility. The plaintiff pleads factual content that allows the court to draw the reasonable inference that defendant is liable for the misconduct alleged. Determining whether a complaint states a plausible claim for relief will be a context-specific task that requires reviewing court to draw on the judicial experience and common sense. Put another way, the plausibility requirement calls for enough fact to raise a reasonable expectation that discovery will reveal evidence supporting the claim. The amended complaint focuses broadly on two types of claims. First, the Wayfarer Parties claim that Lively, assisted by Reynolds and Sloan, stole the film from Baldoni and Wayfarer. Yes, it does. Threatening to refuse to promote the film and attack Baldoni and Wayfarer in the press if the Wayfarer did not agree to grant her rather than Wayfarer control over credit for the film. Yes, and she did. She did threaten so many times to not even use Taylor Swift's music, to do this, to do that, if, to not promote the film, if they didn't do that, et cetera, et cetera, et cetera. I mean, right? The Wayfarer Parties seek damages for this conduct based on a legal theory that Lively, Reynolds, and Sloan committed civil extortion. Second, the Wayfarer Parties claim that Lively, Sloan, and Reynolds and the Times spread a false narrative that Baldoni committed sexual misconduct towards Lively, and the Wayfarer Parties then engaged in a smear campaign to ruin her reputation. The Wayfarer Parties claim that by doing so, Lively, Reynolds, Sloan, and the Times committed the torts of defamation and false light. Although these two types of claims are the focus of the amended complaint, the Wayfarer Parties also bring claims for breach of contract, tortious interference with contract, or prospective economic advantage and promissory fraud. The Wayfarer Parties cannot recover for Lively's alleged actions to steal creative control of the film from Baldoni and the Wayfarer Parties. Oh my gosh. Again, this is like morality versus legality. Morally, I think Ryan and Blake should be in jail. I don't think they should ever work again in Hollywood. I think we should stop talking about them. We should stop photographing them. We should stop having them for interviews. We should stop everything. No more. Into oblivion means literally gone and you're forgotten about, okay? That's why I don't want to cover any of the big headlines or the tabloids or anything today, and I just want to read from this court document because it's like, morally, I think that they should never work again for what they've done here. This isn't the first time. Ryan did it on Deadpool. Blake did it on that other movie that she did that I can't even think of now. It wasn't The Shallow, something. I'll find it. Ryan did it again with his friend Rob McElhenney. If you haven't seen those videos, I just posted 2 in-depth videos on how they stole from gaming creators here in Canada, in Montreal, and then further harassed and mocked them from it. And now they're doing it to Baldoni and Wayfarer people. This is a pattern of abuse, harassment, and creative control, and I would love it to never have to see them ever on my screen ever again. Ever. Because they are mean, big, yes, powerful, yes, rich, ochre, but mean monsters who steal. You think if you had all of that money, Ryan and Blake, you would just come up with your own stuff. Write your own freaking movie, Blake, but you don't like doing that, do you? You've even admitted to yourself that you would rather go in and take over than create something of your own. And that, to me, is so disgusting. I digress. Regardless of the propriety of these actions, they do not constitute civil extortion under California law. California courts have recognized a claim for civil extortion in situations where a plaintiff gives a defendant money or property under threat and seeks to have it returned. However, the Wayfarer Parties have not adequately alleged that Lively's threats were wrongful extortion rather than legally permissible hard bargaining or renegotiation of working conditions. Additionally, the Wayfarer Parties have not shown that some of Lively's alleged extortionate acts damaged them. The Wayfarer Parties also cannot recover on their defamation claims. The Wayfarer Parties have not alleged that Lively is responsible for any statements other than the statements in her CRD complaint, which are privileged. The Wayfarer Parties have alleged that Reynolds and Sloan made additional statements accusing Baldoni of sexual misconduct, and that the Times made additional statements accusing the Wayfarer Parties of engaging in a smear campaign. But the Wayfarer Parties have not alleged that Reynolds, Sloan, or the Times would have seriously doubted these statements were true based on the information available to them, as is required for them to be liable for defamation under applicable law. The Wayfarer Party's additional claim also fails. Accordingly, the amended complaint must be dismissed in its entirety. However, the Wayfarer Parties have leave to amend their claims for breach of implied covenant and tortious interference with contract. So because they didn't lose any money, there was no money exchanged by Blake's threats. Therefore, it does not constitute civil extortion because there is no exchange of money, okay? Again, morality, legality. It is sick. Choice of law. The Wayfarer Parties pleaded their claims under California law. Lively agrees with the Wayfarer Parties that California law applies to the claims asserted against her. However, Sloan, Reynolds, and the Times argue that New York law applies to the claims against them. This dispute is important because New York and California law differ in a number of ways relevant to the Wayfarer Parties' claims. New York law does not recognize causes of action of civil extortion, false light invasions of privacy, or negligent interference with prospective economic advantage. In addition, although the elements of defamation under New York and California law are generally similar, the New York Constitution provides independent protection for statements of opinion, and these two states have different statutory privileges against defamation. As to the claims against Sloan and Reynolds, the court is unable to determine what law applies at this stage. The Wayfarer Parties' defamation and false light claims are based on allegations that Sloan made false statements in text to a Daily Mail reporter, that Reynolds made false statements that Baldoni was a sexual predator, and that both Sloan and Reynolds participated in a campaign to leak false information to the press, all of which occurred at unspecified locations. The civil extortion and false light claims against Sloan and Reynolds are based on essentially the same allegations, as are the claims for tortious interference against Reynolds. Because it is unclear from the pleadings where the facts underlying the claims against Sloan and Reynolds occurred, the court cannot dismiss the claims based on a holding that they must be brought under New York law. If the allegations state a claim under California law, the claim must be followed to continue until such time as the facts developed show California law does not apply. Therefore, the court will analyze the claims against Sloan and Reynolds under California law for purposes of this motion. However, the defamation and false light claims against the Times must be analyzed under New York law, in which the Times published an alleged... There was already a lawsuit before against the New York Times. I mean, there's probably been many, but in this specific one, Kinsey versus New York Times, the New York Times published an allegedly defamatory article regarding events that took place in the District of Columbia and affected the plaintiff's employment there. The circuit distinguished between defamation cases involving a targeted publication in which the state of the plaintiff's domicile will usually have the most significant relationship to the case, and multi-state defamation cases in which an allegedly defamatory statement is published nationally and the plaintiff suffers harm in every state simultaneously. New York had the most significant interest in litigation because the New York Times is domiciled in New York. The allegedly defamatory statements emanated from New York, and New York has strong policy interests in regulating the conduct of its citizens and its media. New York law to a defamation claim against the New York publisher involving California citizens and events. So they're saying that they're just going to use New York when it comes to the New York Times. Impermissible pleading. All defendants argue that the amended complaint should be dismissed without further analysis because it engages in impermissible group pleadings and otherwise violates Federal Rule of Civil Procedure 8. So they're saying because they grouped everyone in together, how are we supposed to know this, it's not fair. They're saying that we did all of it. Which is literally what Jed Wallace said in Texas, and then Blake came back and said well, we only used your name 6 times. Figure it out, bud. It's just so whatever, But he's saying that this issue is compounded by the fact that the complaint's length and tangents make it difficult to understand exactly how the facts alleged provide a basis for plaintiff's claims. Rule 8 does not demand that a complaint be a model of clarity as long as it provides fair notice of what the plaintiff's claim is and the ground upon which it rests. Dismissal under Rule 8 is usually reserved for those cases in which the complaint is so confused, ambiguous, vague, or otherwise unintelligible that its true substance, if any, is well disguised. The Wayfarer Parties' amended complaint is lengthy and repetitive, and it relies heavily on group pleading, but it is not so confusing or lacking in substance that dismissal is appropriate. Thank you. Finally, something freaking accurate. Although the amended complaint lacks clarity as to the boundaries of certain claims, defendants have adequate notice of many core claims that are evident from the face of the complaint and have been fully briefed by the parties. For example, it is evident from the language of the complaint that the civil extortion claim is based on Lively's refusing to promote the film unless she was allowed to create her own cut, Lively demanding with extortionate threats that Baldoni and Heath support her PGA certification, and Lively and Reynolds attempting to force Baldoni and Wayfarer to read a statement apologizing for issues with the film. It is evident that the defamation claim is based on Lively, Sloan, and Reynolds providing the CRD complaint to the Times before it was released and stating to the Times in substance that the Wayfarer Parties engaged in sexual inappropriate conduct towards Lively and retaliated against her for reporting the misconduct by engaging in a campaign to ruin her reputation. Sloan and Reynolds making additional statements that Baldoni had committed sexual misconduct, and the Times stating that Baldoni, Heath, Abel, and Nathan had engaged in a smear campaign to ruin Lively's reputation. Where the amended complaint does not lack clarity, the court will consider only the claims of which defendants have fair notice. To the extent a fair reading of the amended complaint does not provide notice that the Wayfarer Parties are making a particular claim against a particular defendant based on a particular statement, the court will not parse through the various allegations and documents to determine whether a claim could theoretically be stated. For example, although the amended complaint alleges the CRD complaint has was rife with lies and doctored evidence, the court will not consider whether the CRD complaint contained any defamatory statements beyond those specifically alleged in the amended complaint. So just because it says, oh, they're lying, this is all not true, it doesn't clearly state what the lies are and what isn't true. Each single one. Bam, bam, bam. Similarly, in analyzing the defamation claim against the New York Times, the court will not consider whether any statements in the article are defamatory beyond those identified in the amended complaint. The Wayfarer parties have no obligation to identify the statements which harmed them, rather than gesturing a document or category of statements and focusing the defendant to guess at which ones are actionable. Likewise, if the complaint uses the lively parties or Wayfarer parties in a context where a particular plaintiff or defendant is not clearly indicated, the court will not guess at what claim the amended complaint is attempting to make. Such a course could promote litigation by ambush, allowing plaintiff to use vague pleading to hide the claims only to spring them on defendants in opposing briefing or at trial. In opposition briefing or at trial. Accordingly, though, the court will not strike or dismiss any allegations on Rule 8 grounds. The court will consider only those claims that a reasonable defendant would understand to be asserted against is based on the allegations in the amended complaint. So we get into civil extortion. The Wayfarer party's first claim is for civil extortion under California law against Lively, Reynolds, and Sloan. They go into a bunch of laws that were go for and pro, or going for, you know what I mean. Lively, Sloan, and Reynolds have the better of the argument. So they each argued, which one it is, which one it was. And they're saying Lively and Sloan has the better argument. So, of course, the Wayfarer parties here argue all of the stuff that Lively did. She said that she wouldn't return to set and these things were done. She refused to shoot certain scenes. She threatened to not produce the film. I mean, all of the stuff that she did, and you could pause to read if you want. Then Lively, Sloan, and Reynolds argue that none of that was alleged acts are wrongful and that they did not obtain any money or property from the Wayfarer parties. Therefore, it's not civil extortion. And what the judge is saying is that Lively, Sloan, and Reynolds have the better of the argument when it comes to the civil extortion. Governing law. The parties advance different understandings of the tort of civil extortion under California law. Lively, Reynolds, and Sloan argue that the civil extortion is a cause of action for monies obtained by duress, which is separate from the crime of extortion and requires proof of actual damages. The Wayfarer parties argue that civil extortion is a cause of action based on the criminal extortion statute, and that it does not require money or property actually be obtained. Lively, Reynolds, and Sloan are correct. Although the claim is labeled civil extortion, it is derived from the common law rather than the criminal extortion statute, which requires actual damages. Blackmail and extortions are, in almost all jurisdictions, crimes, not civil causes of action. Yeah, crimes. They're criminals. These people are I've been screaming this from the rooftop. These people are criminals. The fact that they did a fake lawsuit to even do a sham subpoena, to even get these phone records are absolutely insane. But the fact that they threatened this man over and over and over again to give him what they want so Blake Lively could freaking claw her way to act like she was the director and she was the executive producer and she made this movie is, oh my God. The crime of extortion involves the obtaining of property or other consideration from another with his or her consent induced by a wrongful use of force or fear. What just happened? Does this not sound like what happened? The crime of extortion involves the obtaining of property or other consideration from another with his or her consent induced by a wrongful use of fear or force. What did you think they did? Anyway, we continue. California permits plaintiffs to bring a claim labeled civil extortion. However, an action for extortion under California law is more appropriately considered a claim for monies obtained by duress. Although the concepts of duress and criminal extortion are similar, the lineage of the tort clarifies 2 points important to this case. First, If a threat would not support a contract claim for duress, it is not sufficient to support a tort claim for civil extortion. Second, and of equal importance, in order to state a civil extortion claim, the plaintiff must allege that they suffered damages or lost something of value as a result of defendant's threat. The threat alone is not sufficient. Then in the footnotes, it says, some cases have stated that there is no private right of action for extortion under California law. However, the holdings of these cases is simply that there is no cause of action for civil extortion based on criminal extortion statutes. A plaintiff may bring a civil claim for extortion under California law. Such a claim is based on the common law concept of duress. 1. A plaintiff may bring a civil claim for extortion under California law. 2. Such a claim is based on the common law concepts of duress. And 3. A plaintiff may not recover on such a claim unless she actually paid the demand or conveyed something of value to the defendant. So he's not disagreeing that this stuff is wrong and it's shady and it wasn't right morally, but under what they put it as, the civil extortion as well as what they did or how the Wayfarers pleaded it in their amended complaint, it wasn't enough. That's all he's saying. Like, he's not saying that it's frivolous or whatever. It added that duress does not exist if the plaintiff had a reasonable alternative to the parting with the consideration to satisfy the false claim, which should be judged by the standard of a reasonably prudent person. Each of these cases involved a suit to recover money paid under a threat of wrongful prosecution. So he named a whole bunch of other laws and cases that's where he's pulling from. As stated in Leaper, this type of claim sounds is restitution, the return of money or other property obtained through an improper means to the person from whom the property was taken. Money paid to prevent the unlawful taking or detention of property may be recovered back. The doctrine is an equitable one and is founded upon the theory of the moral duress not justified by law. Accordingly, a civil extortion claim under California law will not lie in the absence of a threat that would be sufficient to support a claim of duress. Duress generally exists whenever one is induced by the unlawful act of another to make a contract or perform some other act under circumstances that deprive him of the exercise of free will. If a given threat is sufficient to void a contract, it is also sufficient to reverse a non-contractual transaction. If a threat is not sufficient to void a contract, it is also cannot justify reversing a non-contractual transaction. And then he states this claim. Furman also makes clear that civil extortion claims require actual damages and that she apparently never paid. So in this claim, it was no money was transferred here. The Wayfarer people didn't actually lose anything by Blake Lively and Ryan Reynolds threatening them over and over and over again. They went along with it. They just gave Blake whatever she wanted. So what they could have done is not and then sued her, I guess, or whatever. This is what happens to good people, I swear to gosh. Further evidence that the civil extortion claim requires damages comes from the repeated statement in the California cases that duress is a species of fraud. Extortion is the substance of a fraud claim, when duress involves some type of coercion other than the pressing of a false claim, it is literally a form of fraud. Under California law, unless the plaintiff merely seeks to rescind the contract, it must suffer actual monetary loss to recover on a fraud claim. Monetary loss is measured by out-of-pocket damages, which are directly to restoring the plaintiffs to the financial position enjoyed by him prior to the fraudulent transaction, and thus awards the differences in actual value at the time of the transaction between what the plaintiff gave and what the plaintiff received. Monex directly conflicts with Foreman, and its logic is inconsistent with the California decisions deriving the tort of civil extortion from the concept of duress rather than the criminal statute. Accordingly, to plead a tort claim for civil extortion under California law, it is neither necessary nor sufficient for a plaintiff to plead the elements of criminal extortion. Instead, the plaintiff must plead a wrongful threat constituting duress to which the plaintiff's acquisite causing damage. B. Application. The Wayfarer Parties' civil extortion claim is based on allegations. And then they say all of the things that Lively refused to do and all of her threats to the film. The last set of allegations is not actionable because Wayfarer did not acquiesce in the threat and did not accept blame for problems during filming. Wayfarer did not lose anything, and Lively and Reynolds did not gain anything from those threats. The remaining allegations must be dismissed because the allegations regarding Lively's wrongful threats are conclusory and fail to support that the threats were wrongful. In addition, the Wayfarer parties have failed to plead that several key instances of alleged extortion caused actual monetary loss. The Wayfarer parties focus significantly on the demand by Reynolds and Lively that the Wayfarer parties issue a self-destructive statement taking blame for Lively's press woes, or else the gloves would come off and they would attack Wayfarer in the press. However, the Wayfarer parties refused to issue any such statement. Accordingly, there were no reliance on the threat. The Wayfarer parties did not give up anything to Reynolds or Lively, and plaintiff did not sustain damages cognizable in a cause of action for duress. Dismissing claim when it is unclear that damages were proximately caused by the alleged attempted extortion. The Wayfarer parties allege that in response to threats that Lively would stop acting in the film or breach her contractual obligations to promote it, they were forced to agree to the return of production demands, give Lively greater control over the script, give her a producer credit, and support her in seeking her the PGA mark, and accept marginalization from the premiere. However, Wayfarer does not plead sufficient facts to support an interference that these threats were legally wrongful. Lively did not threaten to physically harm the Wayfarer parties or their property, nor did she threaten a false lawsuit as in Leeper and Fornam. And then in the footnote, the complaint alleges that Lively subsequently followed through on her threat by providing false information about the Wayfarer parties to the Times, but that conduct is actionable, if at all, under the law of defamation and not under the law of civil extortion. It does not support an interference that the Wayfarer parties gave anything to Lively or that Lively obtained anything from the virtue of the threat. The Wayfarer parties' claims do not turn on what Lively threatened to do, but what she threatened not to do. The Wayfarer parties allege that Lively threatened to refuse to promote the film or approve any related marketing materials and threatened to abandon her contractual obligation to promote the film or approve marketing materials. However, the Wayfarer parties do not allege facts showing that Lively had an obligation to promote the film or to approve marketing materials. They do not point to any contractual provisions, explain what Lively's contractual obligations were, even explain what contract is being referenced. On that note, too, I do want to say that Lively herself in her complaint has done breach of contract too. So we'll see, because she's never even put a contract. The Wayfarer people never even put her contract either. So it is like they're both arguing contracts, but where's the contract? Okay. Similarly, with regard to Lively's refusal to attend the premiere with Baldoni, the Wayfarer parties do not allege that Lively had any obligation to attend the premiere with Baldoni. While the Wayfarer parties plead that Lively had an obligation to act in the film, they do not allege that she had an obligation no matter the circumstances. As a refusal to provide that which one has no obligation to provide is not a threat, it is a bargaining position. Conclusory allegations are insufficient to plead a breach of contract and are therefore insufficient to plead that Lively threatened a breach of her contract. Then in the footnotes, it does say the failure to specify what Lively purportedly threatened is fatal to any claim based on this allegation. Lively's contractual obligation to continue acting in the film is unclear. Moreover, assuming the Wayfarer parties did not plead that Lively refused to do that which her contract required her to do, that would not alone be sufficient to plead that such a refusal was wrongful and could support a claim for civil extortion. It thus is not uncommon in commercial relationships that one or the other party will demand that a condition to their agreement change before performance is rendered. A refusal to perform unless the counterparty agrees to additional consideration for a new term may, depending on the circumstances, give rise to a claim for breach of contract, but not civil extortion or whatever, A bad faith threat to breach a contract may constitute economic duress. However, such a bad faith threat must be distinguished from an attempt to press a claim that is within a party's rights. In determining whether a threat constitutes economic duress, courts focus on whether the threat is made for some purpose unrelated to the contract or involves a disproportionate exchange of value. To allege a civil extortion claim, the Wayfarer parties must therefore allege facts supporting that the threats were unrelated to or disproportionate to the obligations Lively had assumed under her agreements with the Wayfarer parties, and that the Wayfarer parties had no adequate remedy and could not have refused her demands. The facts alleged do not support an economic duress claim. The Wayfarer parties first alleged that Lively threatened to stop acting in the film unless they agreed to her return to production demands. The court assumes, though it is not explicitly pleaded, that Lively had a contractual obligation to perform in the film, but the Wayfarer parties do not plead that she had an obligation to perform no matter the conditions on the set, and it is not unusual for employees to seek changes or improvements in workplace conditions. The demands Lively is alleged to have made, including that there be no physical touching of her except in connection with her character or scene work, and that there be no discussion of personal experiences with sex, that she have a personal representative on set, and that there be a nudity writer, and all closely related to the conditions of her own performance are largely involved adherence to protections for Lively and other cast members that the Wayfarer parties had already implemented. The only apparent cost of the Wayfarer parties was hiring an additional producer, which would not financially benefit Lively. The allegations do not support that Lively was attempting to extort the Wayfarer parties into hiring a producer, as opposed to seeking to confirm previously understood terms and conditions, or at worst seeking slightly more favorable terms of employment. Even if they turn out to be unneeded, an employee can insist on protections at a workplace for sexual harassment without being accused of extortion. If an employer exceeds, it cannot later claim to be a victim of the employee's wrongful threats. A similar result applies with respect to the Wayfarer parties' allegation that Lively threatened to breach her contractual obligations to promote the film unless they allowed her to edit the movie and released her cut, gave her producer credit, supported her in seeking the PGA mark, and co-founded a screener of her version of the film. Those demands do not involve a disproportionate exchange of value, as Lively insisted on taking on additional work for no additional pay. How nice. Then it does say in the footnotes here, although the Wayfarer parties allege that the list was drafted for the apparent purpose of insinuating or outright claiming that Baldoni, Heath, and others had engaged in sexual inappropriate conduct, there are no allegations that Lively threatened to reveal such behavior if her demands were not met. There is no allegation that Lively had a contractual obligation to promote the film. If not, there is no basis to assume that the value that she conveyed in terms of her willingness to promote represented anything other than a fair trade for the Wayfarer party's willingness to use her cut. Her demands were related to the subject matter of the contract, as Lively sought to have a film she would be promoting fit her vision. She doesn't get a vision. She doesn't get a vision. She's the actor. What vision? She's an actor. These demands were crazy. I'm actually like, this is what I've been saying since the beginning. The Wayfarer should have said no a long time ago, but there is no shoulda, woulda, couldas, you know? I'm sorry. It's just when I read something like this and I'm just like, her demands were related to the subject matter of the contract, as Lively sought to have the film she would be promoting fit her vision. She doesn't get a vision. She was the actor that was hired to play Lily Bloom, not hired to be the to get the freaking PGA mark, okay? I'm sorry. I had to let it out. I'm so sorry. Noting that the threat to disclose criminal activity entirely unrelated to any alleged injury suffered by the demander was evidence of extortion, emphasis added. Although the Wayfarer parties alleged that they did not believe Lively deserved a producer credit or PGA mark, they also alleged that Lively took over significant production responsibilities, stating that Lively used baseless sexual harassment allegations to assert unilateral control over every aspect of the production, alleging that Lively seized creative control over the production and the Wayfarer parties were deprived of the opportunity to produce, credit, and market the film, suggesting that a threat is not wrongful if it has a nexus to a plausible claim of right. The Wayfarer parties have not alleged that Lively requested changes in the production for some purpose unrelated to the contract. The amended complaint alleges that Lively believed her vision of the film to be better than the vision favored by the Wayfarer parties and that her efforts deserved recognition. Lively and Reynolds' efforts failed to win them the acclaim they believed they so richly deserved. Well, yeah, I like that. I like that. The amended complaint is not clear whether the Wayfarer Parties, as opposed to Sony, had the ultimate right to choose the cut of the film that would be distributed or marketed plan that would be used to promote the film. This is very true because, like, Sony didn't. Wayfarer should have had all of the control, but I think because finally they were working with a huge distribution team like Sony, they allowed Sony to kind of walk all over them. And I feel so bad for the Wayfarer people because it looked like they let everyone walk all over them, from Ryan Reynolds all the way to Blake Lively, all the way to Sony. Like, you know, my heart today is so sad for them, knowing that they've gone through all of this and these friggin' people came and just have ruined their lives. There are indications from the amended complaint that such rights resided with Sony. Lively's extortionate threats coerced Sony to allow her to create her own cut of the film, stating that Lively insisted on her screening her own cut of the Sony's objection that Sony informed Wayfarer that Baldoni could not attend, noting that the marketing plan for the film was created by Sony. If so, Lively would not have been withholding from the Wayfarer Parties anything that the Wayfarer Parties had a right to obtain from her in the first place. But even assuming that the Wayfarer Parties had such a right against Lively, they were not without a remedy. If in fact Lively announced that she would not perform unless the Wayfarer Parties gave something of value to her to which she was not entitled, the Wayfarer Parties could have sued. They were not without a reasonable alternative to meeting Lively's demands. Although the Wayfarer Parties state that Baldoni was forced to choose between killing the film and his own career by insisting on his own creative vision and rights, at the point these threats were made, filming was complete. If the Wayfarer Parties had the right to put out a film with Baldoni's edits in the first place, they were not without ability to do so as a result of Lively's demands. The only loss would have been Lively's promotion of the film, but there is no allegation regarding Lively's obligations to the Wayfarer Parties regarding promotion. And even if there were, although the film might be less profitable without Lively's promotional effort, the desire to avoid a loss in profits is not the same as duress within the meaning of the law. Well, hear me and hear me good. If Lively's in a movie, it's going to go under, okay, for the next unforeseen future, in my opinion. Okay, so Sony, y'all here now. You wanted Lively so badly. You wanted her so badly that you could never say no. You wanted her so badly to promote the movie. Who's next? I would love to see who's next putting her front and center in anyone's movie again, other than Paul Feig. The plaintiffs would have brought suit against Lively for damages, but for what appeared to them to be in good business reasons, they elected not to do so. The fact that a plaintiff decides it is more financially beneficial to acquiesce to a demand than to sue does not mean the plaintiff lacks an adequate remedy in damages. Having made their decision, the Wayfarer Parties cannot now seek to recover in damages for what they would have attained had they not agreed and had Lively promoted some different version of the film more consistent with the Wayfarer Party's artistic vision. Finally, the Wayfarer Parties allege that Lively's threat to boycott forced Baldoni to accept marginalization from the premiere. Initially, the Wayfarer Parties do not allege that Lively had an obligation to them to attend the premiere, but much less to attend the premiere with Baldoni. However, even if Lively had such an obligation, her suggested modification is directly related to the conditions of her own performance. There is no threat, extrinsic and unrelated to the production of the film. There is also no disproportionate exchange of value, as the separation of the parties at the premiere is not alleged to have any financial implications. Yeah, but they did have to throw a whole separate party for Blake Lively so that she can promote Betty Boos. And Wayfarer, do you know what they went? They had their own party. And do you know what it was? It was a dry party. No alcohol, because the movie is about freaking domestic violence, Blake Lively. Lively, Sloan, and Reynolds also argue that the Wayfarer Parties did not allege damages from any of the Lively threats. For reasons largely stated above in the analysis of disproportionate value, this provides an alternative basis for dismissal for most aspects of the extortion claims. The court assumes without deciding that an extortion claim could be based on the transfer of creative control if, as a result of such transfer, the plaintiff lost something of value for which it did not receive equivalent or greater value in exchange. However, the Wayfarer Parties have not alleged that Lively's editing or the eventful release of her cut of the film caused them actual monetary loss. Although the Wayfarer Parties preferred Lively to take less of a role in the production of the film, they do not allege that it made less money due to her editing. Or, not her editing, come on. That girl don't know how to edit a movie. Please, okay? She hired editors. But yes, her edit of the film resulted in cost to them. And now look at just in the footnote. I mean, you could read the whole footnote here, but just look at the bigger part that I highlighted. It's very interesting. It says, however, there is no principal reason that the claim should be limited to money or tangible property. How Wayfarer possessed the film rights to It Ends With Us and therefore had the right to control the film without be produced and released based off the book. Had a party demanded at gunpoint that the Wayfarer Parties employed a novice to edit their film, and this caused the Wayfarer Parties damages, the Wayfarer Parties might be able to bring a civil extortion claim. Well, damn, sorry, you know what? Blake and Ryan just seem to have forgot their guns at home. You know what I mean? Like, when you're put into this type of situation where it's either like lose everything or just give Blake whatever she wants, it is like a gun is to your head. Like, they've worked their entire lives and careers to have this kind of opportunity. And these people came and took it from them. Anyway, accordingly, there are no factual allegations that could support an award for damages for the difference in actual value at the time of the transaction between what the plaintiffs gave and what we received. Accepting the allegations, Wayfarer gave up on releasing its preferred version of the film cut by Baldoni in favor of a version that Lively preferred, but there are no allegations that Baldoni's version of the film was of greater value than Lively's. For that independent reason, the Wayfarer Party's civil extortion claims related to the demands for creative control fails. Similarly, although the Wayfarer Parties allege the conditions at the premiere were demeaning and humiliating, they do not allege any cost to Wayfarer. There are no allegations supporting that providing Lively a producer credit and a PGA support resulted in monetary loss to the Wayfarer Parties. The injury the Wayfarer Parties focus on regarding the PGA mark is essentially a moral injury. Morality versus legality, a moral injury that they believe that Lively did not perform the duties of a producer and therefore did not merit the PGA mark, but were forced to write a letter omitting the truth. Finally, there are no allegations supporting Reynolds or Sloan's liability. The Wayfarer Parties argue that Sloan and Reynolds are liable in conspiracy because by actually spreading defamatory statements, Sloan and Reynolds played the role of the heavy carrying out Lively's extortionate threats. However, the only instance in which Lively and Reynolds allegedly threatened to spread defamatory statements was in demanding that the Wayfarer Parties make harmful public statements. As stated above, the Wayfarer Parties never provided such a statement, so no conspiracy related to the statements is actionable. In addition, if Sloan and Reynolds actually spread defamatory statements, they would be liable in defamation, not civil extortion. Finally, the Wayfarer Parties' allegations regarding the purported conspiracy to commit civil extortion are entirely conclusory. The Wayfarer Parties' claims for civil extortion must be dismissed. Defamation. The Wayfarer Parties bring defamation against all defendants. Then they go over what those defamation statements are, which I think we all know by this point exactly what was said. You know, there was by Leslie Sloan, Ryan Reynolds, the New York Times. But then he says these allegations fail to state a defamation claim. Legal standard. The court refers to the California law in setting out the legal standard for defamation, leaving any distinguishing aspects of New York law for discussing as applicable of the times. Defamation constitutes an injury to reputation by a false oral or written communication. California defamation law incorporates, as it must, speech protections required by the First Amendment to the United States Constitution. Publication does not refer to a written dissemination as suggested by the common meaning of that term, but merely requires communication to that statement to a third person who understands its defamatory meaning as applied to the plaintiffs. Because the statement must contain a provable falsehood, courts distinguish between statements of fact and statements of opinion for purpose of defamatory liability. If a statement cannot reasonably be interpreted as stating actual facts, it is protected by the First Amendment and is not actionable. However, the publication may be actionable if a reasonable hearer of fact could conclude that the publication statements imply a provably false factual assertion. To determine whether a statement is actionable, fact, or non-actionable, courts apply a totality of the circumstances test pursuant to which they consider both the language of the statement itself and the context in which it is made. Where the plaintiff is a public figure or the speech involves a matter of public concern, the plaintiff bears the burden to show the falsity of the statements. Then they go into what it means if you're a public figure, not a public figure, what you have to prove, and you have to prove actual malice. And then it does go into, the fair reporting privilege. So several privileges under California law may prevent an otherwise defamatory statement from being actionable. Relevant here, California recognizes a litigation privilege, a fair report privilege, and a privilege for statements by the victim regarding an incident of sexual assault, harassment, or discrimination. The litigation privilege is an absolute privilege that applies to any communication, 1, made in judicial or quasi-judicial proceedings, 2, by litigants or other participants authorized by law, and 3, to achieve the objects of the litigation, and 4, must have some connection or logical relation to the action. It aims to afford litigants and witnesses free access to the courts without fear of being harassed subsequently by derivative tort actions. The privilege applies not only to court proceedings, but to all kinds of truth-seeking proceedings, including administrative, legislative, and other official proceedings. The fair and true privilege applies to a fair and true report in or communication to a public journal, judicial, legislative, and other public official proceedings, or anything that said in the court thereof. Fair and true in this context does not refer the truth or accuracy of the matters asserted in the proceedings, but rather to the accuracy of the challenge statements with respect to what occurred in the proceedings. Lively, Sloan, and Reynolds. The Wayfarer parties allege generally that Lively, Sloan, and Reynolds worked together in advance a fabricated narrative in the press that the Wayfarer parties had sexually harassed Lively, then embarked on a calculated and malicious smear campaign to destroy her reputation as retaliation for daring to complain about the harassment. The general allegation has multiple facets. Most prominently, the Wayfarer parties allege that Lively, Sloan, and Reynolds worked together to spread a false narrative to the time. In addition, the Wayfarer parties allege that as part of some conspiracy, Sloan and Reynolds individually made false statements about BALDONI to other press outlets and BALDONI agency. The Wayfarer parties have not adequately alleged a defamation claim as to any part of the purported conspiracy. The Wayfarer parties have not adequately alleged that any false statements were made to the Times other than the statements in Lively's CRD complaint, which were privileged under California law. There is also no allegation that the distribution of the CRD complaint was made by anyone other than Lively, or more particularly with the involvement or agreement of Sloan or Reynolds. The Wayfarer parties have not adequately alleged that Sloan or Reynolds individually did any more than repeat Lively's version of events, which they had no reason to doubt. And the Wayfarer parties have not adequately alleged that Lively should be held responsible for Sloan and Reynolds' statements. Their allegations of a conspiracy between the parties are conclusionary. So they're just saying that, Leslie Sloan, maybe she did say all of this stuff. Ryan Reynolds, yeah, maybe he did do all of that stuff, but they were only repeating what Blake told them. So how were they to know that it was fake or false? And also, it's all in her CRD complaint, so they, by all means, should know that it was true. Then we get into the New York Times, and there is a lot about the New York Times, but pretty much Fair Reporting Act, they're saying that because Lively eventually did file her CRD complaint in order, it wasn't at first, the lawsuit or anything, it was the CRD complaint. Because she did that it was okay for the New York Times to use it because it was the Fair Reporting Act, because it was used, regardless of the time, regardless of that. But it does, even though we know that they were working on the story long beforehand, that doesn't matter, because what he's saying is that they did put in the statement that the Wayfarer's response is, and also there is no contract between the New York Times and them, because the New York Times asked for a statement, they got a statement, and they picked parts of the statement to put into their claim, as well as the New York Times also said that this is all coming from the CRD complaint. And yes, there were texts that were in the New York Times article that were not in the CRD complaint, but they do state that they went through thousands and thousands of text messages. That's just to sum it up. And then it also has nothing to do, and then what he's saying is this also has nothing to do with Ryan Reynolds or Leslie Sloan, because it only makes sense that the CRD complaint was given to the Times by Lively or someone acting on her behalf. If the complaint was provided by the Times, it is likely that Lively played a responsible part. The act of providing the CRD complaint to the Times is not sufficient to constitute defamation because the complaint is protected by the fair report privilege. The CRD complaint is a filing in a quasi-judicial proceeding. So they were just reporting fairly on what Blake Lively put into the CRD complaint. It even says here, under the California law, a party need not wait until a legal document is formally filed before providing it to members of the press. The fair report privilege extends to advance communications to the public journal of a complaint so long as the party intends in good faith to file in a public official proceeding. Assuming the lawsuit is actually filed, the statements will also be privileged when published by the media outlet. Applying the fair report privilege in this situation protects the bridge between these two privileges, of avoiding the result in, then they gave the case Shabar, that is intermediately could be held liable for defamation for passing along statements that are privileged on each end. So long as litigation was actually contemplated seriously and in good faith, the fair report privilege applies to a party who communicates a complaint to the press before that complaint is publicly filed. Here, there is no basis to infer anything other than the litigation was actually contemplated seriously and in good faith. In the first place, Lively commenced litigation. She filed a CRD complaint within months of the events described in the CRD complaint, and not long after it was plausibly given to the Times. 11 days after she filed the CRD complaint, Lively filed suit in this court, making the same allegations that she made before the CRD complaint. So what this court is saying, and what Judge Lyman is saying, is that Lively's actions support rather than detract from the interference that the administration complaint was filed as part of a genuine attempt to pursue Lively's claims. Because the Wayfarer Parties were saying she just filed the CRD complaint and the New York Times and stuff to take down Wayfarer. And he's saying, well, it seems like it was a genuine attempt because, now we're here and in this court. Next, we go to the sexual assault and sexual predator statements made by Sloan and Reynolds. The Wayfarer Parties separately alleged that Sloan and Reynolds made defamatory statements that Baldoni was a sexual predator or committed sexual assault. Specifically, the amended complaint alleged that Sloan blah, blah, blah. Yeah, she told the Daily Mail person that Justin Baldoni sexually assaulted Blake Lively, and Reynolds told WME over and over again that he was a sexual predator. The Wayfarer Parties have not alleged that these statements were made with actual malice. Their claim thus fails. A false accusation of sexual assault or similar sexual misconduct can support a defamation claim. Sexual assault is a crime and an allegation for criminal activity is defamatory per se. A statement that an individual committed sexual assault would generally be understood as a statement of fact. Likewise, if the context of it ends with us and Reynolds' relationship with Lively, the comments from Reynolds that Baldoni is a sexual predator could reasonably be understood as a claim of fact that Baldoni had engaged in sexual misconduct towards Lively. However, the Wayfarer Parties have not alleged that Sloan or Reynolds had knowledge that these statements they are alleged to have made were false, or that they entertained serious doubts as to their truth. Because Baldoni is a public figure, he may only recover if the statements were made with actual malice, meaning actual knowledge of falsehoods or reckless disregard for the truth. What? Of course they knew this whole thing isn't true. It's oh my God, I can't believe Lively has gone this far. And she's been lying and lying and lying and still continues to get away with it. At the pleading stage, a plaintiff in federal court cannot simply state in a conclusory fashion that a defendant knew a statement was false. He must plead facts demonstrating that the claim of actual malice is plausible. Although actual malice is a state of mind, it can be proved by circumstantial evidence. Direct or circumstantial evidence thus must be pleaded. Evidence may include allegations of failure to investigate, anger and hostility towards the plaintiff, reliance upon sources known to be unreliable, or the plaintiff's possession of contrary information. And then in the same breath, then they go into Sloan and they say that she wasn't on set. She doesn't know. She's not Lively's custodian, he puts it. She's her PR agent. So everything she was saying, she believed to be true coming from her client. Therefore, she's not responsible for it. Sloan is not alleged to have any reason to believe that Lively was being untruthful. The statements was contained in a legal filing on behalf of and by a person whose credibility the Wayfarer parties do not allege Sloan had reason to doubt. Moreover, once Sloan credited Lively's account of the facts, she also could have reasonably and not recklessly concluded that Baldoni had engaged in sexual assault. Although sexual assault has many different legal definitions, Sloan's is not a lawyer and is not alleged to have used the term in a legal sense. The Wayfarer parties argue that as a close associate of Lively, Sloan had a motive to defame Baldoni. First, aside from the generic premise that Sloan was Lively's publicist and was one on Lively's side of the conflict, no allegation suggests any particular benefit Sloan would derive from telling a falsehood in this context. Are you kidding me? Do you know how much money Leslie Sloan makes from Blake Lively? Of course, she has every single reason to do whatever she has to protect this good girl, oh, so innocent Blake Lively freaking image. Ugh, let's move on. Anyway, that's basically all it says over and over and over again in all these different ways is that, one, she believed it to be true, and two, she's no lawyer, so how did she know what she was saying is da-da-da. Then it comes to Ryan Reynolds. The Wayfarer parties argue that Reynolds defamed Baldoni by telling WME executive at a premiere of his Deadpool and Wolverine that Baldoni was a sexual predator and using the same term in a phone call to Baldoni's agent. The term sexual predator is broader than the term sexual assault, and in this context could reasonably be understood to imply that Baldoni engaged in sexual misconduct towards Lively. However, as with Sloan, Reynolds was not present for any events during filming. He was on set though. What husband goes on set? Oh my gosh, I'm sorry. I told you guys I would keep it cool, and I really did for a long time. But when it comes to Ryan Reynolds and Leslie Sloan and Blake Lively and Stephanie motherfucking Jones, I just can't. Because I know everything that they did now, and I would need clear evidence to sway my thought. I mean, I'm still open to be proven wrong, but I haven't seen anything to support anything that Blake Lively and her freaking dragons have even insinuated happened, okay? So that's what they're saying. Same thing with Sloan. Reynolds was not present for any events, and the amended complaint does not provide any reason he would have doubted Lively's versions of events. In fact, several allegations in the complaint support that Reynolds believed that Baldoni engaged in sexual misconduct towards Lively. During pre-production, Reynolds screamed at Baldoni after finding out Baldoni had asked his trainer about Lively's weight. Reynolds then later yelled at Baldoni and demanded that he apologize for actions that had never happened in connection with the return to production demands, becoming further enraged when Baldoni refused to apologize. Given that the return to production demands concerns Baldoni's alleged inappropriate behavior towards Lively, the obvious inference is that Reynolds was yelling about Baldoni about his alleged behavior. These facts tend to suggest that Reynolds believed that Baldoni had inappropriately commented on Lively's body and then engaged in inappropriate or predatory actions towards Lively during filming. The Wayfarer parties argue that actual malice can be inferred from Reynolds' deep disdain for Baldoni and the fact that he was trying to convince WMD to drop Baldoni, in which he made the sexual predator statements. But as noted above, actual malice refers to knowledge of falsity or recklessness with respect to truth rather than a motive to harm, and motive alone is insufficient to show actual malice. Then it also goes into the Nice Pool character. Remember that? How he once again took from people's real life. He did this with the gamers. He did this in Deadpool and Wolverine. This is what Ryan Reynolds always does. Takes the people that he doesn't like and severely makes fun of them and portrays them awfully in all of these little jabs that he does. But the judge is saying here that he doesn't think that Nice Pool's or Ryan Reynolds' portrayal of Nice Pool could be defamatory. The portrayal of Baldoni as a fake feminist who makes inappropriate comments is clearly subjective and unverified opinion. So then he just says Leslie Sloan and Ryan Reynolds, they didn't know that what they were saying were false. They were just believing everything that Lively told them and everything that she put in her CRD. And then he says that the Wayfarer parties must plead more than factual allegations that Sloan and Reynolds made false statements combined with a bare assertion that the statements were false. There's a lot more that it says about Sloan and Reynolds, but it's kind of all the same thing that, they just didn't know. They thought that it was true. And then it comes to the New York Times too, And it's pretty much exactly what we all thought it was going to be when it comes to the New York Times, is that it was fine. Like, I'm going to sum it up. What they did was fair reporting. They had the CRD complaint. They had all the evidence. They put together an article in which the article does say that we pulled it from here and these are our things. And it does say that the statements in the article and the video regarding the alleged sexual harassment are subject to the fair report privilege and were not plausibly made with actual malice. It is plausible that the statements in the article and video that the Wayfarer Parties engaged in a smear campaign are not subject to the fair report privilege, but the Wayfarer Parties have not alleged that those statements were made with actual malice. So it could be, but they didn't say that. So I don't know if he's actually giving them a little like hint, hint, nudge, nudge here, but we'll see. It is interesting though, because in some parts, like here, he wrote like the court cannot conclude at this time if the privilege applies. They do talk about also that 4-minute video that the New York Times put out, where even that metadata shows that they worked on that video on the 12th of December, but then they put the story out after that. So it's just very strange, but he knows about all of that. And again, he's just saying the Wayfarer Parties failed to allege that the Times made this statement with malice. So we'll see what happens there. But right now, even drawing all reasonable interference in favor of the Wayfarer Parties, the evidence does not support that the Times would have held such doubts that what they were saying were not true. And then they do say that they did have all of the text that they showed, you know, in the article about we can bury her, this looks like it would be us, all that stuff. And he says it is fair to presume that the Wayfarer Parties did what they said they planned to do. So even though the art talks about like, should we unleash our plan? We have this going on, they never actually did it. That's what the Wayfarer people are doing. Yeah, we had all of these plans, but then we didn't have to do anything. And the judge is saying, well, the New York Times, how are they supposed to know that you didn't actually do what you said that you were going to plan to do? So those messages are what is contained in the article and referenced in the video, and a reader of those messages would have little doubt that the Wayfarer Parties engaged in a smear campaign by reading it. The Wayfarer Parties relied on other text messages, also alleged reviewed by the Times, which suggests that negative publicity Lively was attracting derived from sources other than Nathan and Abel. For example, Nathan and Abel sent each other BALDONI specific stories that described as completely unsolicited and not from any of us, and similar phrases. Nathan and Abel stated to BALDONI that negative publicity was reacting to Blake's own actions in interviews, was organic, and that they were doing all of this by themselves. So he's saying that they did put in kind of like both sides to the story. These messages do not show that the Times had a high degree of awareness that the Wayfarer Parties probably did not engage in a smear campaign. At most, the messages reflect the Times chose among a number of possible rational interpretations of a document that bristled with ambiguities. Ambiguities. Oh my God. Which is not enough to create a jury issue of malice. Then it says the alleged facts indicated that the Times reviewed the available evidence and reported, perhaps in a dramatized manner, what it believed to have happened. The Times had no obvious motive to favor Lively's version of events. Please, give me a break. They had really no reason. No reason to favor Blake Lively and Ryan Reynolds and Leslie Sloan. Give me a break. Though the article largely follows the narrative of the CRD complaint, it includes additional context favoring BALDONI. It acknowledges criticisms of Lively's promotional efforts and comments that it is impossible to know how much of the negative publicity was caused by the smear campaign. Yes, it does say that, but the majority of it was definitely pro-Blake and crapping all over Wayfarer and BALDONI. Like, let's be real. And it does also say, like, with the text messages from Nathan and Abel and the Wayfarer people and there is, the Wayfarer Parties complaint is that overall smear campaign narrative is defamatory. But given the strength of the CRD complaint and all the evidence and all the text messages, given the strength of the evidence, they might have been in favor of a smear campaign, because it is not plausible that the Times entertained serious doubts as to the truth of the smear campaign narrative as a whole, even if for whatever reason it misrepresented one particular set of messages in aid of that narrative. And then lastly, the false light. The Wayfarer Party's third cause of action is for false light invasion of privacy against all defendants. California law recognizes a false light claim for an invasion of privacy by publicity that places that plaintiffs in a false light to the public eye. The false light must be highly offensive to a reasonable person Yeah, B, it was. You know what I'm saying? In addition, the defendant must know or act in reckless disregard as to the falsity of the publicized matter and the false light in which the plaintiffs would be placed. The court has already explained why the Wayfarer parties do not state a claim for defamation based on these allegations. To the extent that the Wayfarer parties mean to allege that Lively provided selectively and deceptively edited text message to the Times through the CRD complaint, such communication was privileged. To the extent that the Wayfarer parties mean to allege that she separately provided selective edited text, the amended complaint is conclusory. The Wayfarer parties cannot benefit by the expedient of simply relabeling their defamation claim as false light. The Wayfarer parties otherwise concede that the false light claim stands or falls based on whether it meets the same requirements as the defamation cause of action. Accordingly, the false light claim must be dismissed for the same reasons as the defamation claim. Then, breach of implied covenant of good faith against Lively. The Wayfarer parties allege that Lively breached the implied covenant of good faith and fair dealing in the contract, by which Lively agreed to perform as an actor in the film It Ends With Us by making threats, seizing creative control, and depriving the Wayfarer parties of the opportunity to produce, edit, and market the film by contemplated by the contract. California recognizes an implied covenant of good faith and fair dealing in every contract that neither party will do anything which will injure the right of the other or receive the benefits of the agreement. What they're saying is currently, right now, the Wayfarer parties' breach of implied covenant allegations are conclusory. The Wayfarer parties do not plead the terms of a relevant contract, which the Wayfarer parties it was with or when it was made. The amended complaint contains vague references to contract negotiations or entitlements, but it also indicates several times that Lively did not sign her employment contract for the film. The Wayfarer parties do not allege any particular contractual provisions that gave any particular Wayfarer party to the opportunity to produce, edit, and market the film, or that prohibited Lively from involvement in the production, editing, or marketing of the film. They therefore do not identify any contractual provisions the exercise of which Lively frustrated. The Wayfarer parties attempt to specify the relevant contractual provisions in their opposition briefing. The breach of implied covenant claim is dismissed. Tortious interference with contractual relations or prospective economic damage. The Wayfarer parties allege that Lively and Reynolds intentionally interfered with the contract between the Wayfarer parties and WME by making threats to induce WME to drop Baldoni. They also allege in the alternative that Lively and Reynolds intentionally interfered with the prospective economic relationship between the Wayfarer parties and WME, and as a further alternative that Lively and Reynolds negligently interfered with the relationship between the Wayfarer parties and WME. So then he just talks kind of about what that means, the California law, what tortious interference is, and how that's done. And then he just says the Wayfarer parties failed to allege facts regarding their relationship with WME to support any of these torts. The amended complaint alleges that WME is Baldoni's agent, that Lively, Reynolds, and Wayfarer and Baldoni were represented by the same talent agency, and that Reynolds told WME that the agency was working with a sexual predator and demanded that they drop Baldoni. However, the Wayfarer parties do not allege that they had contract with WME, where the contract is, how they interfered, how Reynolds knew about the contract, etc., 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 or how it was disrupted, or how the Wayfarer parties were harmed. This is fatal to all three claims because there is no claim in the absence of facts showing that the relevant economic relationship existed and was disrupted. Then it goes into promissory fraud and breach of implied contract against the New York Times, which was kind of what I talked to you about when they said that, you know, they asked for a response, they gave them a certain time, then they responded, but then before that time, the New York Times actually put out this story anyway. He's just saying that all of that doesn't make any sense because there was really no contract, because you said that you were going to give them an answer. They asked for a response. You gave them an answer. And then even though they still put out the article at 10 o'clock in the morning, they said noon, there was no agreement to go like back and forth or for you to like approve the article or anything like that. So I think that one kind of like does make sense. Then this is the last little bit. The court will not grant leave to amend the majority of the Wayfarer parties' claims because amendment would be futile. The dismissal of the claims does not rest on technical pleading claims, and the Wayfarer parties have not made a showing that the complaint's defects can be cured. However, the court will grant leave to amend the claims for tortious interference with contract and breach of implied contract. Motion for fees. Reynolds, Sloan, and Vision PR have moved for an award of attorney fees and costs pursuant to New York's anti-SLAPP law, New York civil rights law. Lively has moved for an award for attorney fees, treble damages, and punitive damages pursuant to civil Code. The court denies the motions without prejudice to renewal in accordance for the ruling here. The court has ruled that the law applicable to the claims against Reynolds and Sloans cannot be determined absent further factual development. The court has not ruled on whether Lively's statements were privileged under California Code 47.1. If defendants choose to renew their motions, they shall fully brief the impact of this opinion, if any, as well as the issues raised before briefing. And that's pretty much it. I mean, I skimmed a whole bunch and skipped a whole bunch. And for time's sake, and I already know people are going to be like, oh my God, this video is so long. It's so long. I know. And I didn't even go over everything. That's how much there is. Okay. But I wanted to give specific details. And I'm so sorry. Even halfway through that, I just wanted to cry. Like, I'm just like having a morning. Like, I woke up this morning. The dog has been very sick to its stomach. I mean, but through its butthole all morning. Woke up to that. That was awful doing that. And then I got my lady time. That was brutal, of course. And then I opened the court documents and then read this. And I was just like, cool. What a day. What a day. So this is, obviously a major setback, but I do not doubt the brilliance of Brian Freeman and his team. And maybe they were expecting this. And honestly, maybe they just wanted to get all the information out there so that everyone knew, and now they're just going to defend themselves. Who knows? I don't know what's going to happen. That's the information. I'm not happy with it. I think it's a shame. I think that these people have been getting away with so much for so long, and I was really hoping that for once in their life they would have to be accountable for something. Let's see by June 23rd what the Wayfarer people come up with. Again, I'm just, having a day, but I still chose to show up. I didn't even want to get ready for on camera, do my hair and makeup or anything, but I was like, you know what? It's important that I just sit here and do the video and get this information to you and just show up and, just get it out of my system. But it's not going to lie, like, it's a pretty heavy day for anyone that's been fighting. But I just want to leave you with, it's never wrong that you fought for your rights. Never be ashamed whether you win or you lose. If the truth is on your side and you have been wronged and you have been violated and you've had monsters like Blake and Ryan come to try to destroy you, and you are fighting for your rights and you are standing up to the Goliaths, if you're David, and maybe you don't win that fight. Maybe you don't win that battle, but never be ashamed that you stood up for yourself. Oh my God, I'm so sorry. I'm so emotional today. Like I said, I started my lady time, so I'm just like very heavy today, very heavy in my heart. And yeah, so just, this is a setback and this does suck for sure. But he fought and he is still going to fight and he is still going to defend himself. It's not over. This sucks. It's definitely not a win to anyone saying that this is like a win or something for Wayfarer. It definitely isn't. But the silver lining is now we know. Like, we know the truth. And whether it's done in the courts or not, the court of the opinions of the public people, okay, the opinions here is that y'all need to go to jail. You need a big old timeout because we don't want to see you. I don't want to hear your names. I don't want to see your face. I think y'all are monsters, okay? But yeah, just continue to keep fighting for the light. Keep fighting for what's right, using your voice to advocate for those who cannot, and never ever feel defeated or shameful that you stood up to monsters and to the dark in this world, okay? No matter the outcome. We know who the real monsters are in this story, and we will continue fighting for Justin Baldoni, Jamie Heath, Steve Soritz, Melissa Nathan, Jennifer Abel, and Jed Wallace, collectively, the Wayfarer Parties. Thank you so much. I hope you have or had the most amazing day, and I'll talk to you soon, okay? Love you. Bye.